may or may not do that. I got a lot I'd like to say about that. But, Mr. Speaker, I think you have a couple of important rulings today to make with respect to the constitutionality of the governor's actions, which we're considering today. And I wanted to make sure Mr. Speaker was aware of our position on the law of the subject, because I'm not sure how much debate we're actually going to have on that when the time comes. And I also want to make sure that the public had an understanding of where we, what our understanding as to what.
Is the gentleman making an announcement or a point of personal?
Point of personal privilege, Your Honor.
Okay.
Thank you.
You call me Bill.
No problem. Thank you, Mr. Speaker. First of all, the governor's power to line item veto is set forth in Article 5, Section 6 of the Constitution, and it's very clear the governor has the power to line item veto an item or items in an appropriations bill. And I don't think there's any issue. We have an appropriations bill here. The issue that's going to be before you, Mr. Speaker, is exactly whether or not the items that the governor has vetoed constitute separate items. And the Supreme Court has looked at that now twice. They've looked at it once in the Dodson case and a second time in the Brault case. And the 1940 involves 7 different line item vetoes. And the Supreme Court gave us a roadmap as to how we are to look at these things when they come down, because they don't come down very often. And to lay out a hypothetical, the Supreme Court gave us a pretty, I think, simple hypothetical to understand how these work. They said that items of money to construct a building, a certain amount of money for the architect, amount for the physical infrastructure, a certain amount for the heating. And if the governor were to come down and say, strike out the architect, but leave the money in for the fiscal plant, leave the money in for the other parts of the building, that wouldn't work, because it does damage to the surrounding legislative tissue, as they say, and you can't build a building without an architect. Mr. Speaker, the Supreme Court then went on to quote a United States Supreme Court case in defining what an item of an appropriations bill is. And one of the interesting things they wrote was, an item of an appropriation bill obviously means an item which in itself is a specific appropriation of money, not some general provision of law which happens to be put into an appropriations bill. So in other words, the idea is you don't legislate through the budget. You don't put general law in the budget. And that comes up from time to time in this body. And some of us have a view about some of the things we're doing today with regards to that. They also went on to define an item later in the case. And they said that in Virginia, notwithstanding what the U.S. Supreme Court said, that in Virginia, an item in an appropriations bill is an indivisible sum of money dedicated to a stated purpose. It is something different from a provision or condition, and where the conditions are attached, they must be observed, and where there are none, none may be added. And they go on to talk about how if there's any unconstitutional provisions in a bill, they ought to be struck out, because it would be silly to ask the keeper of the rolls or a clerk to be putting unconstitutional provisions in a bill. They went on in the Brault case, which came down, I guess, in 1976, which was actually, I thought, a very interesting case. It's all about the Metro situation. I guess the General Assembly, back when Metro was being constructed, appropriated in item 826 of that bill $125,000 per year for Metro, for general Metro aid, then $1.3 million per year for Metro capital costs, and then $5 million per year for 2 years for construction of Metro rail. And all of those items were contained within the exact same budget item in the budget. And the Supreme Court went on to analyze that. And in analyzing it, they noted that they don't question that in some sense that all those 3 appropriations were tied up with one another. And that they all relate to the same general subject, and they're all grouped within the same numbered item. They also went on to note that while that was the case, that if it is clear with the disapproved provision eliminated, the approved appropriation's contended purpose, the attempted invalidation, is invalid. Which they went on to talk about how at the oral argument, it was conceded that if you struck out the money for the Metro capital construction, the rest of it could survive. It would not affect the remaining appropriations. And they said that that was a a welcome, candid concession, because that typifies the sort of extrinsic practical consideration that we believe must be excluded in determining whether the appropriations relating to the same subject are legally interdependent. And they went on to say that because you can strike that $5 million and not affect the others, that was a proper line item veto. Now, Mr. Speaker, what we have here before us, I think, there's at least two, maybe three, depending upon how accurate the rumor mill is, that Your Honor is going to be considering this constitutional issue on today. But first of all, with respect to the whole Merck issue, which I believe is one of them, there's nothing about Medicaid that needs to have Merck. Merck doesn't need Medicaid. Medicaid doesn't need Merck. If Merck is gone, Medicaid lives on. Merck is not a condition on an appropriation. The state does not need to have Merck to continue spending that money. It is a standalone issue. It's an issue that can be debated by itself. And the fact that the Appropriations Committee chose to stick it in the same item in a budget is not something that binds the Supreme Court, or any court for that matter, in interpreting whether it's an item. The same thing with the Stanley Amendment, the so-called Stanley Amendment, Mr. Speaker. The Stanley Amendment, that can survive. Medicaid can go on as it exists with or without the Stanley language. And the Stanley language, in fact, is written so broadly, many of us believe that actually constitutes general law. And a lot of people in here talk about legislating through the budget. Don't legislate through the budget. We shouldn't do that. And Mr. Speaker, many of us think that's exactly what we've done here. Now, whether you call this legislating through the budget, log rolling, which is how another thing, the Supreme Court of Virginia called it log rolling. Another one of their opinions, they said we need to avoid log rolling. Some people call it legislative twister. These are things that you don't do. And this is exactly the kind of thing the light item vetoes were designed for, was to prevent that. And many of us, Mr. Speaker, took your caucus at its word when you all said you wanted a clean budget, you wanted to decouple Medicaid in the budget, and Medicaid expansion from the budget. What that Stanley language did was recouple it up real hard. It stuck it right back in. And Mr. Speaker, it's my hope at the end of the day that we get a vote on taking it right back out. Thank you, Mr. Speaker.
Gentleman from Fair.